I just saw two Liberals stand up. It appears they wanted to take the time here, Mr. Speaker. And it's actually, one of them was the member for Winnipeg North, and I really enjoy his interventions on the law. So, you see, Mr. Speaker, we are talking about the law today, and one of my favorite aspects of our banter in this House with the member from Winnipeg North is on Bill, he said it's C2. And it was really interesting to hear him talk, because now he will often get up and, dare I say, pontificate on the law when it comes to these issues. And on C2, he repeatedly told us, I would even, again, let's call it pontification, about how somebody needs a search warrant to get access to mail, when clearly in the legislation it says the corporation may open up any mail to see if it contravenes the legislation. Now, the member for Winnipeg North should be applauded for his zeal in this regard. I love not only how often he says something, but the fervor with which he says it. Unfortunately, Mr. Speaker, the problem is, Mr. Speaker, his officials contradicted this very thing. So we spent literally days in the House of Commons debating about mail. So when he gives us exhortations on the legal front, I hope this time he has done his homework. Mr. Speaker, well, he tells us he was right the first time. Yeah, I don't want to say someone's wrong, but Mr. Speaker, through you, I say you're wrong. Mr. Speaker, on to something a bit more serious. I learned recently that a person from Kamloops, Thompson Nicola, Fred Sawada, who was uncle to one of my friends, someone I went to kindergarten with, Christy Sawada, brother to her father, Jack, recently passed away. They did a lot for the community. They ran service stations, one of which was just a few blocks from where I grew up. My deepest condolences to Fred's family. May perpetual light shine upon him. Mr. Speaker, I also would like to take this time to recognize Ari Yurkinen, a young man from Kamloops, Thompson Nicola, who contributed tremendously to democracy in the last year, someone that was of great help with me. So I want to give him a shout out. His father, Ken, is a veteran of our Canadian forces. We thank him for his service. We thank the family for all they've done. So I wanted to give him a shout out. Now, Mr. Speaker, I was actually on the phone with a prosecutor not long ago. And one thing they said that is deficient in this bill, perhaps the member for Winnipeg North already knows what I'm going to say, but one thing that's deficient from this bill is Section 525 of the Criminal Code. Now, this varies from region to region, but what Section 525 is it's a review of bail. So normally, when somebody was left in custody, the principle was nobody should be languishing in custody after charge approval. So back in the day, for instance, I once saw in my prior career, I saw a murder file from 1984, I believe, and the file was about this thick, which is what, like, now a theft file looks like. And trial dates were set, I think, on the third or fourth court appearance. In other words, people got to trial. It got done. Now, people don't get to trial oftentimes for a year and a half, 2 years. It was actually this mentality that beckoned to the Jordan decision. But we have this antiquated law that says there should be a bail review after 90 days in custody. So, and this is assuming a person has only one file, because Section 524 operates. I'm not here to give a discourse. I'm here to raise this issue. Section 525 operates that, let's say somebody is in custody on an indictable matter, say a robbery. They have a bail hearing at day 81 of detention, which can happen. You could just put it off. Counsel can put it off. The person says, I want to apply for bail at day 81. If that person is detained at day 81, by virtue of the operation of Section 525 and how it's been interpreted in British Columbia, I'm told, that person can then have a review of their bail 9 days later. Now, this obviously is completely antithetical to what we intend. If you want to have a review of bail it should be an appeal of bail. Now, a review and an appeal are two very different things. An appeal is saying the judge messed up. A review is meant to address this ongoing languishing that we don't want people to do when their matter hasn't gone yet to trial. To me, this is something that needs to be addressed. Now on to sex offenses. I am trying to think of how many times I have said in this House. I rose in this House, in fact, I questioned Minister Lametti when he was the minister about this very issue of house arrest for sex offenders. In fact, I put it to him in committee, Mr. Speaker, that there was a mother that offended against her own child, facilitated an offense. It was absolutely disgusting. I put it to him in committee. Thankfully, it was overturned on appeal. That mother got house arrest. I've said it no less than probably 20 times. I gave a speech on this very issue probably 2 weeks ago about house arrest for sex offenders. And every single time the Liberals looked the other way, Mr. Speaker. Nothing to see here. There's no issues. We were constantly told it's the province's fault. Look this way. Look that way. There's no problem with bail. We got it figured out. Ministers Varani, Lametti, they actually told us there was no problem. And yes, I'm speaking with a great deal of passion because I can't tell you how many victims have suffered as a result of that inaction. They would say the provinces are responsible for the administration of justice. Yes, but you know what, Mr. Speaker? The provinces interpret the laws that we make in this very House. And those ministers, along with many of the people that are in this House right now, hopefully one of them will be permitted to get up on a question, told us we were out to lunch. This is on sex offenses against children, house arrest. This is nuts. Absolutely nuts. Mr. Speaker, another aspect of clarification that we need to look at is in the reverse onus provision itself. I will be candid. Reverse onuses typically had their place, but we've heard from the Liberals so often about reverse onuses. Here's the issue with a reverse onus. When you're in one reverse onus, when I say when you, Mr. Speaker, not you when you're in a reverse onus, when an accused person's in a reverse onus, typically, not always, but from my experience, they're actually in 2, 3, 4, 5. You could have somebody that is subject to literally 10 reverse onuses, right? So we have to recognize that. The second issue with the reverse onus is oftentimes it will apply to indictable offenses only. So when the issue was changed in sentencing that said just about every summary conviction offense could get 2 years less a day, when that changed, I believe the motivation behind that was to put more things in provincial court, which operates in a more streamlined manner. Okay, fine, no issue there. But what that means is Crown would proceed by indictment. For those watching, they don't know the difference. Felony versus misdemeanor. Summary versus indictment. And then we have hybrid offenses where the Crown can elect which is which. The whole point was so that the Crown would elect summary. So the reverse onus says if somebody has committed an indictable offense, then they're in a reverse onus. Well, what about somebody who has 80 convictions, but the Crown expects to seek 18 months jail, which is fairly serious jail? They elect to proceed summarily. That person, according to my information, in certain provinces, depending on the jurisdiction, will no longer be subject to the reverse onus provision. So we actually have a stymieing of legislative intent there. That's something I really, really hope that the Liberals deal with. The last thing missing from C-14 is Bailey's Law. Let's hope the Liberals don't heckle on this time. The reality is we need to pass legislation on intimate partner violence. We need to create a specific offense on intimate partner violence. We need to recognize the scourge and the plague that is intimate partner violence, and I exhort this House in the strongest language possible to pass Bill 225 with the urgency it deserves. Thank you, Mr. Speaker.
Questions and comments. Question et commentaire. L'honorable député de Madawaska.
The honourable member for Madawaska Restigouche. Thank you very much, Mr. Speaker. We want to protect our communities, and our new Liberal government has taken a serious approach to fighting crime. We have a number of bills. We've invested in law enforcement, and now Bill C-14, which makes more than 80 changes to the criminal code to have more serious sentencing and stricter bail conditions for repeat offenders and those who commit violent crimes. The Canadian Association of Police Chiefs has called on all parties to rapidly pass this bill to improve public safety and improve trust in our justice system. Does my colleague agree with the Canadian Association of Chiefs of Police that we need to rapidly pass Bill C-14? Thank you, Mr. Speaker.
Member for Kamloops, Thompson-Nicola.
I see Liberals are clapping. I wonder where that type of urgency was when we had our Jail Not Bail Act. That bill, and I'm going to look right at my colleague, was endorsed by many of the same organizations that are endorsing this bill. So the Liberals are content to say, you need to pass this right away because these law enforcement bodies are telling us we need this. Where was that urgency from the Liberals when the MP from Oxford put forward his bill? When the Police Association said, we need this bill, where were the Liberals then? They voted against it. So it's quite hypocritical for them to say, oh, we need to pass this right away. And by the same token, well, we don't need to pass things that the police chiefs say unless it's Liberal legislation. We will scrutinize this legislation and do our best. Thank you.
The honourable member for Brantford South, the Six Nations.
You got it. Thank you, Mr. Speaker. My colleague gave an excellent speech. He referenced Bailey McCourt, the tragic, preventable homicide that is still on the books in British Columbia. That was a result of a decision made by a judge to release after conviction pending sentence. Bill C-14 does not close that gap. What does Jail Not Bail Act say in reference to that type of process? Good question.
The honourable member for Kamloops, Thompson-Nicola.
Mr. Speaker, I appreciate the question from my colleague for Brant. When somebody is convicted, the presumption of innocence is gone. I have no problem talking about the Conservative position on bail, which is generally that bail has become too loose, and I believe that this bill actually could go much farther. But I also believe that when the presumption of innocence has been displaced, as my colleague just mentioned, we need to be acting in a different manner. The principle of innocent before proven guilty has been displaced. Now, the principle of restraint is still on the books in such situations. I understand and I recognize that Bill C-14 addresses the principle of restraint to a certain degree. It does attenuate it, but it doesn't remove it. I would go so far as to say that that principle of restraint needs to be reworked. It was common law, it needs to be readdressed. Thank you.
Very briefly, the honourable member for Shefford. Thank you, Mr. Speaker. What we're studying right now, this question of Section 810 and minimal sentences, at committee we're studying this, but what we're hearing and what we've heard in previous studies, Mr. Speaker, when it comes to intimate partner violence is also the question of the Jordan decision. Earlier, a Conservative member spoke about Kate Alexander, who came to committee and talked about her experience as a victim and survivor of intimate partner violence, and she would like to see changes to the Jordan decision because right now there are criminals who are able to get out because of delays. So in crimes that are of a sexual nature or murder, how can we change the Jordan principle to better help victims?
Kamloops, Thompson-Nicola, very briefly, because we have to.
I'm just going to be quiet because this is actually an important question and there is a lot of chatter in the House. To my friend's question about the Jordan Principle, an incredibly critical question. The Jordan Principle will delay charges because we are waiting far too long in order to institute charges because the clock starts ticking. So a sexual offender who offends against a woman on day 1 may not be charged till day 365 so that we don't start the clock ticking. What happens in that day? That delay is critical to protecting people. I agree with my colleague that we must address Jordan in this House. It's time. Thank you.
There will be, well, basically that's the all the time for Q&A and comments.